From classroom quips to Bollywood movies, the phrase 420 or 420 is still used to refer to somebody who's a cheat or is dishonest. The practice traces its origin to the Indian Penal Code, in under which section 420 spoke about the punishment for offense of cheating. And this is just to tell you how deeply imbibed the criminal code, the three laws that form the criminal code of the country, were in our usual daily life, because they had been around for decades. But it's time for change now. We know that the three new criminal laws, that is the Bharatiya Nyaya Sanhita, the Bharatiya Sakshya Adhiniyam, and the Bharatiya Nagrik Suraksha Sanhita, are ready to take effect. These will be replacing the old three criminal laws, which is IPC, Indian Penal Code, CRPC, which is Code of Criminal Procedure, and the Indian Evidence Act. And in this video, we'll be focusing on the new law, that is the Bharatiya Nyaya Sanhita, that will be replacing the Indian Penal Code. And for this discussion, I have with me one of India's leading criminal lawyers, Tanveer Ahmed Mir. Thank you so much for joining us, sir.
Thank you very much for having me here.
Sir, to start off with, let's just deal with, I want for our viewers, if you could tell them, why were these laws brought about? What was the need or necessity for these new laws?
Well, right from the independence of India, we are having the CRPC. Earlier it was 1898, that was done away with, and we had a new procedure in 1973.
Right.
Penal code remained the same, and over years there were many amendments. Now, precisely if you ask me as a practicing criminal lawyer, I don't see any reason why the government should have brought these three new laws, both regarding the substantive penal provisions of the penal code, then the CRPC or Indian Evidence Act, because almost about 90% provisions are absolutely same.
Okay.
Which means that even when Government of India was deliberating in the Law Ministry or Home Ministry, writing these laws or sections once again, and unfortunately, as you very well know and every Indian knows, that when these bills were brought in the Parliament, there about 150 parliamentarians were thrown out. So on these three new bills, like any other bill during these last 10 years period of time, was hardly debated. There was no parliamentary committee also. So to cut it short, there was no necessity. Today, there is no necessity to bring these three laws. The new amendments are, totally unnecessary, and they have no relevance. Further, what we see is that there is a concerted effort by the government and dispensation in power to empower and to sharpen the teeth of police authorities more, give them more power in terms of arrest, give them more power in terms of discretion. And this new law is nothing but converting our country, which is a constitutional democracy, where the most sacrosanct rights of basic freedoms are being curtailed slowly. The constitutional freedoms are now only being, rendered as words and letter. These laws seeks to completely mutilate, and they militate against the fundamental freedoms in Article 19 and Article 21 of the Constitution of India. Forget me, the lawyers community is not happy about these laws. And let me tell you that once these laws come into force, there is going to be a huge chaos, confusion, not only in the cops, in the police stations, in the courts, but actual sufferers are the general public at large. Because these laws are targeted ultimately and specifically any kind of people who would dare to question and raise questions out of human curiosity and exercise their fundamental freedoms. So the laws are garnered for political purpose. In this new Suraksha Code, there is no Suraksha for any Indian. And every Indian is being endangered against arbitrary arrest, limited bail, and also more penal provisions, which are totally unnecessary.
Right.
So I don't see any objectives here being achieved from 140 crores of Indians in a bigger perspective.
So you will be getting to the penal provisions very soon. We'll go clause by clause because you've already mentioned that 90% of the provisions remain
Are absolutely same.
Are absolutely the same, and we'll be referring to a lot of them throughout this
Correct,
conversation.
correct.
But before that, you mentioned that there's going to be a lot of confusion.
Yes.
I want to talk a bit about that.
Yes.
Do you think that we're ready for implementation of these laws? Because there are reports that translations are not ready. There will be confusion in police stations with regard to implementation of the laws. Do you see that? Could you elaborate a little bit on that?
Yes, there is certainly going to be a lot of chaos and confusion insofar as the implementation is taken into consideration. And this will burden the courts and justice delivery system more. And I'll tell you why. Because all the pending prosecutions where FIRs are lodged and investigations are continuing or matter is under trial or appeal or revision, the earlier offences will be dealt by earlier law, earlier procedure and earlier Indian Evidence Act. The new offences which are registered post 1st of July, the date on which it commences, will have to be dealt, investigated and tried as per new law. So you go to now a Patiala House Court, and the judge on one hand, now earlier he used to have one court, he will have two courts. Now first case will be under old act, new case will be under new act. So he'll himself not know what to do. So he would also be needed. We have a Delhi, judicial training center in the Shahadra district courts.
Right.
A lot of people will need to undergo training. Even the judges of the High Court will need a lot of assistance from lawyers. The casualty here is justice delivery system.
Right.
So instead of giving, quick justice, we will be delaying the cases more. Because ultimately, Apoorva, the delay in the courts is not on account of slack laws. The delay in justice delivery is because of lack of infrastructure. If you have more cases and less judges, for example, the ratio of judge to the population in the world is worst in India.
So with courts already overburdened, this is only going to, it seems to only going to make the situation worse, essentially.
Absolutely. That's a guarantee.
Right.
That is an absolute guarantee.
Okay.
Yes.
So now moving on to the penal provisions, I'd like to bring here one of the most controversial probably provisions, which relates to the new offence for acts endangering the sovereignty, unity and integrity of India. Now we know that sedition as an offence faced a lot of criticism over the years, and the Supreme Court put the provision on hold. But now the criticism for this new provision has been that it probably has certain elements of sedition in it. Could you please elaborate and comment on this new provision?
Well, the law of sedition under the erstwhile 124A of the IPC was not in Lord Macaulay's code. This was introduced by British imperialist India.
Right.
I believe in 1897, only to curb the movement of freedom and expression of Indians, people who were writing poems or writing articles, so that could be curbed. I believe the first person to be convicted for sedition was Bal Gangadhar Tilak. And even Jawaharlal Nehru, was sentenced 6 times, and he served a sentence as well. The idea post-independence was to do away with sedition as a British legacy. And this was recognized by courts on various occasions. Finally, the erstwhile Honorable Chief Justice Ramana Saab, he put a stay and asked the government that we can't have sedition forever. The government said that even the Prime Minister has given an assurance, which was replicated in the order, that sedition will be done away with. The new law which has come, instead of 124, is sedition multiplied by 100.
Okay.
And it will introduce such a chaos, and it will result in so many freedoms getting curbed. For example, if you see, the definition of sedition is now so vague, it is so wide, and anybody can be implicated. Earlier it was that, you are talking against the government. For example, the word of excitement, attempt to excite, attempt to say anything against sovereignty and integrity is fundamentally to kill your rights under Article 19 of the Constitution. When the basic freedoms were enacted, what the Constitution guaranteed to every Indian citizen was absolute freedom of speech. And the subsequent curtailments or exceptions came in the form of amendments.
Right.
The idea of the legislature and people at large was, as soon as, we from a nascent democracy, we get into a strong, robust democracy over the years, these exceptions shall be done away with. And every Indian will have an absolute right of expression into wanting to express anything, including but not limited to even questioning what part would be integral, what part was historically integral or not. Now, when you have reinforced sedition, it's only a false statement. It's a fluke, which the government lied to the Supreme Court. The new provision is so expansive, so vague, and anybody and everybody now, your virtually freedom of speech is virtually gone.
Okay.
If you just have a look at this provision and
Right.
allow me, we can have
In
a just...
fact, yes, and for our viewers, you can see the provision on your screens right now.
Yes. So if you have the provision, just allow me, I'll tell you how expansive it is. Now, what the government has done is introduced 152 and done away with 124A. It says,
Right.
whoever purposely or knowingly, by words either spoken or written or by signs or by visible representation or by electronic communication or used by financial mean or otherwise excites, attempts to excite, secession, armed rebellion, subversive activities. Now, how are the cops going to interpret subversive activities? Is collection of farmers a subversive activity? Sometimes during a collection of farmers or agitating people over these Agni Veer or any government policy, sometimes, there are even slogans
So
which
open
go
to
beyond.
interpretation,
Yes.
essentially.
Then encourage feelings of separatist activity. What is separatist activity? So nothing has been defined. It is so vague, so wide. Then endangers sovereignty or unity and integrity of India. How are you going to interpret these three words in a factual situation?
Right.
Correct? So therefore, instead of doing away with sedition, which was your promise before the Honorable Supreme Court, you have reinforced sedition multiplied by 10 and deliberately kept it so wide, so vague and so ambiguous, so that ultimate advantage can be taken in specific cases, target-based.
Right. Okay.
And where on one hand you may not, on a particular case you may say, well, start the activity, register an FIR and teach people a lesson of their life. So what I feel is that reinforced sedition therefore is to kill the voice of journalists, independent thinkers, people who are willing out of human curiosity and their fundamental freedoms to talk about anything and everything, spirituality, religion, integration, non-integration, integral part, non-integral part. This is to kill entirely.
Right.
And these provisions will certainly come into play against people who are writing authors, people who write books, who write critical acclaims in terms of social structures. This is to attack them, and this is going to have a very, very strong effect on the society at large.
Right.
Why? You have to enhance the freedom. You're virtually killing the freedom.
Right.
So this is the vast expanse of this whole provision, and God knows what's going to happen.
Right. And a similar provision that I'd like to talk about here is the one that talks about imputations or assertions prejudicial to national integration. Now, if you could elaborate a little bit on this.
Okay. Now, this is virtually the first cousin of the provision which I have said. This was not in the earlier court.
Right.
Now, you would have seen that over last years, there has been a very strong rhetoric based on social media campaigns and hate smear campaigns of labeling people who talk against government, who dare to talk the government as anti-nationals. So the concerted process in this court is not to do away with the colonial law, because you could have shown in the preamble that which part of the colonial law was hurting the fundamental freedoms, was hurting the people of India. That you have not said in the preamble or objectives.
Right.
So what you are doing is, when you call somebody as anti-national, now you have a criminal provision, which is virtually, backing up. And this, a cause for national integration, again, is so wide, so vague, that you can book anybody there for any kind of speech and leave it to the interpretation by the cops.
Right. So I'd like to stick here to the 10% new provisions that we're talking about.
Yes.
Now, moving on to the offense of terrorism, we've always had the Unlawful Activities Prevention Act, which defined terrorists act and terrorism, but this new law also defined it. How does it get implemented on the ground, and what are the differences or similarities, or what are the complications as well that will arise out of this?
Well, this introduction in the Penal Code about the provisions from section 15 to 21 of UAPA 1967 as amended up to date have all been got and brought in one section called 113 in various clauses, of which there is no necessity, neither in the objective of this act nor in the preamble or otherwise. There is no debate. First of all, on these three bills, and in particular to any kind of problematic areas, even when these bills were introduced, it was never referred to any parliamentary committee for a debate, because there was no opposition in the House, which is actually a fraud on Indian people and nothing else. Now, government may have the power. We certainly understand the bill has been passed, presidential assent has come, gazette notification, and law attains, it attains the force of law. Under UAPA, there was the necessity of incorporating UAPA was to curb those organizations who get together with an intent to secede territory from the Indian Union. Over the years, it was amended that forget organizations, even individuals can be implicated.
Right.
Now, there were some very strong safeguards there. For example, sanction. Before you prosecute somebody, those sanctions have been done away with. Virtually all the terror laws of UAPA have been got into the new penal code. And the discretion is with some superintending of police officer in a state, equivalent to Deputy Commissioner of Police in New Delhi and metropolitan areas, that once a case is registered, whether this will be prosecuted under the new code, under section 113 or through UAPA, now you will never see an SP going to UAPA.
Right.
Why? Because UAPA will be NIA.
Right.
Secondly, you will have to seek sanctions.
Right.
You will have to then observe safeguards. Here there are no safeguards. Plus, what does it seek to achieve? When there is a special law like money laundering, you have a special law.
Right.
When there is a special law for terrorism in UAPA, why do you borrow 6 provisions from the UAPA and put them in one provision here and leave it to the whims of a sub-inspector and SHO in police station Kotla Mubarakpur or anybody else? Even the smallest police station now can exercise. So what this will lead to is ultimately more arbitrariness, more power. More power with the cops means more corruption. You see, the very threat of putting somebody tomorrow to the sword of this terrorist law under the new code or old code means that there is a lot of bargaining, which is a reality, and means of more corruption for the executive and the police system.
Right. Okay. So now this isn't, you've spoken about special laws right now with regard to UAPA and how this is being now introduced in this law. But this isn't the only special law that is now being duplicated, so to say, in the new law in Bharatiya Nyaya Sanhita. We also have provisions related to organized crime.
Correct.
I want you to explain how this overlap would function and how would that impact a person who, say, is being accused under any of these provisions.
Well, for example, first of all, when you indict somebody under harsh law, you also have to observe safeguards. For example, the organized crime law was under MCOC, Makoka, which is applicable to Delhi, Maharashtra control. Earlier, it was, Pota or Tada or anything of that sort. Now you have borrowed provisions from Makoka and put them in organized crime here.
Right.
Again, there was a safeguard system there. Safeguard was in the section 23.1 and section 23.2. So before you started an investigation on organized crime cartel, crime syndicates, you had to seek sanction from the government in power. Even before registering an FIR, then you had to seek a second sanction before you could prosecute a person and, file a charge sheet.
Right.
Both those safeguards are done. Now, does it have any objective to achieve? None. Because if tomorrow you were tackling organized crime, you had a law in force.
Right.
So, whilst an ordinary criminal felony could be attended to under the Indian Penal Code and the penal provisions, organized crime for the same cops was amenable. So, a person could be booked under 302, attempt to murder, and he could also be booked under the MCOC provisions.
Right.
Now you have got MCOC here, but you don't have the safeguards, which means that police arbitrariness is on the escalation.
Right.
It is increasing. Discretion is increasing. Now, how that discretion will be exercised, there is no reasonable basis, which means it is whims and fancies of the cops. The basic freedoms, when we have a constitutional democracy, we have checks and balances and we have state accountability. Whilst you see, ultimately any law enforcement agency is accountable to the people of India.
Right.
You are trying to protect cops, empower them more, increase arbitrariness, increase harsh activities, have no accountability, have no checks. And so checks and balances are on decline.
Right.
And how is it going to play out? It is going to play out that, look here, you have two cases. Say a person who committed cheating here and committed cheating in Haryana. Then he will tell him that, look here, now there is amended 113. Either I will implicate 113 or you pay me 10 lakhs. So these, you see, ultimately the laws are the only reason why Arnesh Kumar, in fact, in the judgment of Arnesh Kumar, the Honorable 3 judges of the Supreme Court said that power of arrest is fraught with a lot of corruption.
Right.
Correct? In the executive. So therefore, checks and balances, the judgments were like that, were also in recognition of the fundamental rights and in checks and balances. There are no checks and balances now left. So you are at the whims of the SHO or the sub-inspector or some SP. Now how is he going to decide what will be the criteria where for terrorism to go to UAPA or to retain here? No criteria have been explained in this law that which will be called, or a checklist. What will be that checklist before an SP or a DCP here? कि साहब मेरे को वहां पर इसको UAPA में जाना है या यहीं पर रख लूं?
So it could also lead to subjective implementation of the law depending on who's really deciding what law to apply.
What will it lead to? It will lead to more chaos in the court. So if in one case the SP did not go to UAPA, in another case he went to UAPA, it will result in 3 writs.
Right.
Already there is no high court in the country where any judge of the high court, and I am telling you, the judges are also human beings, they are not robots. Hardly any court, any magisterial court, sessions court will have about 70 to 80 cases on an average.
Right.
And the high courts anywhere have more than 100 cases.
Often more than that. Yeah.
How many cases is the judge supposed to decide? Now what will happen is, instead of 100, you will have 180 cases. And how are we as the legal community then supposed to assist the courts in justice delivery system, when rather than working on the cases, we will be frequently filing petitions against arbitrariness, lock, stock and barrel?
Right. Lock, stock and barrel.
In terms of objectives, there are no objectives.
Right.
We are not seeing any objectives in bringing these provisions. And the concomitant result which I'm seeing, or anybody else or any other legal luminary can make out, well, except people who have to pander to the government narrative, is that the police power, police state is getting reinforced with more teeth, more steel, and less freedoms for the general public at large.
With this, I'd like to take one more provision maybe that is new and that has been introduced in the new code. This is the provision which makes it an offense if a man promises to marry a woman, does not intend to actually marry her, and has consensual sex. Now, this has been a debate within the courts for a very long time now.
Correct.
How does this provision now, how do you see this provision panning out on the ground? Does this settle the debate? How does that?
It doesn't settle the debate, because out of the rape felonies which hit the court on an ordinary basis, more than 85 to 90% cases are these false promise to marriage, which are actually relationships gone sour. And then, the woman using the provision against, Your Honor, the erstwhile boyfriend or anybody else. The concerted judgments which were passed that this does not tantamount to a rape at all. The Bombay High Court, Delhi High Court, hit any High Court, thousands of times the Supreme Court judges and High Court judges said that this provision is getting totally misused. If there would have been a change, this provision had to be done away with. And maybe a case of cheating or something could have been introduced. Here now what is reinforced is also hiding his identity. Correct? Now what is this hiding of identity? How is it going to play out? So it seems to me that the government still wants to latch on to something where it is very strange that people in the law department of Union of India it's not that they are oblivious. They've just turned the blind eye to hundreds of judgments on these provisions, and still retain the old thing, and probably, hide his identity. Tomorrow would be that tomorrow we could implicate somebody in an interfaith marriage on the allegation. So this hide your identity would be that I am in a relationship or something. Tomorrow you will say that I didn't even know that this person is a man of different spirituality or a different religion. So it empowers misuse more. Whilst all over the world, such kind of provisions in 376 or rape are nowhere.
So does this also in a way unsettle the jurisprudence around this, like many other, you mentioned Arnesh Kumar, you mentioned several judgments. So generally, do several of these provisions impact already settled law by the courts?
Yes. A number of judgments, huge deliberations, assistance rendered by lawyers, law clerks, everybody in the judicial, the judges have toiled in writing these judgments so that the provisions are streamlined, and there is coherence, there is consistency. Correct? Now, they've also given many examples how the law is getting misused. Correct? Therefore, it was clear to anybody in the government or as a student of law that these kinds of provisions certainly have to go. But the government still wants to retain them so as to have, opportunities to have more chaos,
and
to have more confusion
as well, probably.
And to misuse them in selected cases. Otherwise, where is the need for you to get UAPA terrorism into the penal code, to get Makoka organized crime into the penal code, to have sedition 124 done away with and reinforce sedition by 1,000 times, have no differential intelligible criteria. You have to have some criteria for the executive on the basis of which how consistently they will be, prosecuting people. In what case you will go here, in what case you will go there. That's nowhere. So when you do not have these kinds of classifications, criteria, guidelines, you end up giving overwhelming power to the executive. And which is totally in derogation of the constitutional freedoms. Today, Apoorva, I see these laws only framed and hurriedly, without referring them to any parliamentary committee for debate, without calling for any comments from the stakeholders, from law professors, researchers, lawyers, legal community, writers, authors, and half of the parliament thrown out. These are geared towards mutilating and destroying the fundamental freedoms in Article 19 and 21. See, Article 21 got a lot of reinforcement in 1977 in Madam Menka Gandhi's case, when the due process of law concept from 5th and 14th Amendment of American Constitution was read into Article 21 by a 5 judges constitutional bench way back then. Thereafter, by the implication of due process, which simply means that anything and everything which executive does, if it is arbitrary, if it is unreasonable, if it is not amenable to common logic, has to be quashed, has to be done away with. So therefore, both our substantive laws, whatever laws you make, they should not lead to arbitrariness. Executive action should also not be arbitrary. It should not be whimsical. It should not be as if you're a king. So today, the SP and the cop, so they will be so happy. वो तो अपनी मूंछों पे ताव दे रहे होंगे कि हमारे पे तो इतना overwhelming power आ गया. And ultimately, they are there to serve. But that's not how in the practical world. In a constitutional democracy, it is important that while there is policing, there are also checks and balances.
Right. And these laws seem to have done away with most checks and balances.
Yes, they are geared towards giving more power, introducing more arbitrariness.
So we've been talking about a lot of new offences that have been introduced in the new law, but there's also a significant omission. It seems significant because we're talking about Section 377 of the Indian Penal Code. We had the Supreme Court striking it down, partially reading it down when it came to same-sex relationships between consenting adults.
Based on consent.
Right, on between consenting adults. But it still applied to non-consensual sex. It applied to bestiality as well. But now that has been omitted. Is there enough safeguard apart from this law to deal with these offences now that they've been omitted?
None. Earlier, you would see so many cases where, a woman would a wife would lodge a case against the husband, good, bad or ugly, or wrong or false, where one of the offences would be 377 without consent. Now you've done away with that. So if tomorrow, the minors are taken care of under POCSO, if you are under 18, there is a safeguard. You have that law where, for a carnal intercourse, irrespective of the sex of the victim, there is a procedure for, penal indictment, trial and conviction. But once you are an adult, 377 is done away with. You rape a man, there is no recourse.
Right. So it takes away those safeguards as well.
Yes, absolutely.
Okay.
So I don't see any logic in that. Neither does the Act say so. Neither does the Act also in its preamble or its objectives set out which were the problematic provisions under the old code, which needed to be addressed again.
Right. That is where I want to come to, and this will be my last question to you, that the stated objective, at least of these laws, when these new laws were being pitched, was decolonizing them. They kept talking about these laws being colonial legacy and how it needs to be done away with. Do you see these laws achieving that stated objective, if at all?
See, this decolonization of the laws is a hollow political rhetoric. It is more for, this WhatsApp university and these false and farce campaigns that the political parties in power run, to poison the people and their minds. Colonial laws were not bad. If they were bad, how have you retained 90%? Correct? Some part of the colonial laws, like sedition and others, needed to be done away with way back in 1952 or 47 or whatever thereafter. You retained them. Correct? So when you are using to do away with colonial laws, you're actually arguing against your own self when you are retaining 90% of the same provisions.
Right.
So the stated objectives are not stated anywhere. I have this book with me. I can show you, Apoorva, that in this book, in any stated objectives, there is nothing stated except a hollow political rhetoric that these were colonial. And there is nothing more. if there was a stated objective, you needed to say which are the provisions which were, on account of they being colonial, were against, constitutional freedoms, against people of India, against the general public at large,
Right.
how they were harming the individual or the general society at large. Correct?
Right.
So today, for example, notable provisions which have been gotten is booking somebody in violation of something called as anti-national, a criminal offense against national integration. What is national integration? How are you going to define national integration? Who will interpret national integration?
Right.
What is national integration to you may not be national integration to me at the end of the day.
Right.
So you have given, these laws are so subjective, so wide, so vague that ultimately, I don't know. I'm sure that some constitutional challenges will be taken.
That's what I wanted to get to. Do you see it surviving judicial scrutiny on the basis of settled jurisprudence?
Well, that is for, the lordships in the apex court and constitutional courts to look at these laws from the point of view of what harm they are doing to the constitutional freedoms. Because after all, Constitution of India and Part 3, which is the fundamental rights, they are supreme and any other law, is subservient to these rights. I hope, believe, pray that their lordships in Supreme Court and other constitutional courts are able to see, through this iron curtain wall which the new government wants to throw at us, and see beyond it as to how the intent is not to benefit the society, but to curb checks and balances, for which tirelessly the legal committee and especially the judges have been working right from 1947.
Right.
So challenges are bound to come. What will happen? We'll have to see.
Of course, we'll have to see.
One more point before we finish, I must say that over the years, somehow and unfortunately, in terms of Vairi's challenges means challenge to the provision that, my lord, this is ultra Vairi's, the Constitution of India, it is against Article 14, it's against 19, it's against 21, it is against the soul of the Constitution, has been rebutted that even if a particular law has a potential of arbitrariness or has a potential of misuse, it may not be struck down just because, misuse may happen subsequently.
Right.
Correct? So I believe that the constitutional lawyers and, people like Dr. Singhvi or Mr. Kapil Sibal, they will be soon, analyzing these provisions, assisting teams will be there. Ultimately, it is for the lordships in Supreme Court,
of course,
to have a look at these laws and any rational basis of getting them into the new court, except, to wipe out the name Indian Penal Code and, to use the word Bharatiya Nyaya. If you want to use Sanskrit words or Hindi words, I don't have a problem. But certainly people down south are already having a problem with this.
Right.
Correct. The Bharatiya Suraksha Adhiniyam is not providing you any Suraksha at all. Let me tell you that since we are not doing this debate on the new CRPC, a lot of constitutional judgments have been sought to be wiped out and reversed in these new laws. But that is for another day. So let's hope for the best.
Yes.
And we will try, as legal community, tirelessly working on, because we are geared towards serving the society.
Absolutely.
In terms of lawyers that we are and, officers that we stand in a court of law. But if the government is not going to help the cause of 140 crore Indians by bringing such kind of draconian laws without any rational basis and, remove checks and balances, I don't think it subserves the cause of society at large at all.
In fact, this entire video series is also a part of this attempt from our side to inform the people and educate them about these new laws, because this is a big change for everybody who's going to be governed by them, and that's the entire country.
That's right.
And on that note, we've reached the end of this episode. Thank you so much for joining us, sir,
More
for
than
that
welcome.
Very enlightening conversation, and thank you for all our viewers for watching.